Testing 1, 2, 3. Testing 1, 2, 3. Testing 1, 2, 3. Testing 1, 2, 3. Testing 1, 2, 3.
Good morning. Our first case for oral argument this morning is Malley versus Illinois State Board of Elections, appeal number 24-2979. Mr. Barnhart, whenever you're ready.
Your Honors, may it please the Court. Andy Barnhart on behalf of Appellant Rochelle Malley. Appellant's injury is her lost confidence in the integrity of Illinois elections due to the use of electronic voting machines, causing her to give up her plans of running for office and serving as precinct committee person, which infringed her First Amendment right to associate. Under the standard of review, appellant has alleged sufficient facts, which must be accepted as true, to make her lost confidence injury plausible, actual, particularized, concrete. First, a couple of facts that this court must accept as true. Appellant Malley did plan to run for office and serve as precinct committee person. And as a result of the use of electronic voting machines in Illinois, she gave up those plans due to her lost confidence. Now, there's a few legal conclusions that are indisputable. In the Seventh Circuit, a person's interest in running for office and serving as precinct committee person is a protected First Amendment right to associate. And according to the Supreme Court, lost confidence in the integrity of elections drives honest citizens out of the electoral process, which plausibly led Appellant Malley to give up her plans of running for office and serving as precinct committee person. So that boils it down to really just one question for the court. Were her allegations of election interference due to the use of electronic voting machines a plausible basis for her to lose confidence? That's the question. Did she make sufficient allegations to make it plausible that she would lose that confidence? Now, I want to just go back and state one thing that the United States Supreme Court says. When I said that the court says that lost confidence drives honest citizens out of the process, this is their quote from Purcell versus Gomez in 2006. Confidence in the integrity of our electoral process is essential to the functioning of a participatory democracy. Voter fraud drives honest citizens out of the process and breeds distrust of our government. Voters who fear that their legitimate votes will be outweighed by fraudulent ones will feel disenfranchised. So it's not a question of whether her lost confidence will cause her to give up her plans of running for office and serving as precinct committee person. The Supreme Court says, yeah, that's what happens. The question is whether she pled sufficient facts to make her lost confidence plausible, and that's what I want to focus on.
She's not alleging any actual fraud, correct?
I disagree with that, Your Honor. And that was really, I think, the premise of why the district
That's what the blue brief tells us.
What's that now?
That's what the appellant's brief told us. Now, I gather you didn't write that, did you?
I didn't, Your Honor.
But it emphasized that her claim does not depend upon any actual fraud in Illinois elections.
And if I could back up to what she actually responded with in the district court in her opposition brief, because the respondents in the district court did specifically argue.
Excuse me, I'm quoting page 21 of the appellant's brief in this court. The plaintiff's complaint was not premised on actual fraud occurring in Illinois, but rather on the inherent susceptibility to fraud of the electronic voting systems used in Illinois. So her claim does not depend upon alleging actual fraud or proving it, correct?
I agree she says that.
And you're disavowing that?
Yes. And can I explain why, Your Honor?
Sure. I'll be very interested to hear.
What matters is what facts were in front of the district court. What I contend is that what she said as a pro se plaintiff in her initial opening brief to this court does not change what was actually available to the district court with regard to facts that she alleged in her complaint. And so if I could, I will point out that at the district court level, when the respondents argued in their brief in support of their motion to dismiss for lack of standing, they said she never alleges past election interference in Illinois. And that's what Your Honor is talking about. And I understand it's critical here. What she says on page 5 of her brief in opposition to that is she says, further, defendants state that my brief contains no facts specific to Illinois. In regards to facts relevant for Illinois, these facts are covered in the number 44, that's the Second Amendment complaint, paragraph 6 through 10, as expert Mars includes in her affidavit that the vote manipulation occurs in all machines as they run the same software, which thereby includes Illinois. And so she specifically refutes that idea that she didn't allege that there was prior vote interference in Illinois due to the use of electronic voting machines. No.
Where in the complaint does she read that? You're reading from the briefing, but where in the complaint?
Paragraph 6 through 10. And that's where she incorporates the Maris affidavit. She talks about the entire breakdown of what Maley and what Helderman talk about, and specifically she cites the fact that all electronic voting systems utilize the same software designed for vote manipulation. That's in her complaint, and so.
But it says he could manipulate.
At parts it says it could, but at other parts.
There's nothing in there that says it has been manipulated.
Your Honor, if you look at Exhibit 8, which she references, and in fact I want to point out that the district court states in its order that the closest that the Second Amendment complaint comes to alleging past Illinois election interference is with regard to how she incorporates Exhibit 8. And I want to talk about what Exhibit 8 actually says, and I want to point out that it's entitled 2020 Presidential Election Startling Vote Spikes. And it is a statistical analysis of state vote dumps in the 2020 presidential election. They say the conclusion is that
is this case then an effort to relitigate the 2020 election totals?
This case is pointing out that her lost confidence is based on what happened in the 2020 election, but due to vulnerabilities that have existed in electronic voting systems since 2000.
Mr. Barnhart, is this a case that, in essence, any voter in Illinois could bring?
No. She's narrowed the playing field considerably for two reasons. One, she's bringing this as someone planning on running for office and having demonstrated that she's been significantly involved in the electoral process serving there. And then further, she's actually incurred a tangible cost by withdrawing her plans to run. As Judge Posner said.
So basically any voter, though, could say, I would have done something differently here.
Well, that voter would have to allege under oath that they've already demonstrated a track record of serving in elections, not just voting.
Okay.
And
Why?
that
Go ahead, Bill.
Oh, no, you go ahead.
Well, I was going to shift slightly, so go ahead, Judge
Well,
Kirsch.
why would they have to demonstrate that?
because that's what particularizes her injury. And I want to just point something out, and then I'm going to have to reserve. Is this my 10 minutes, or was this starting at 8? Because I'm
10.
reserving
You
10.
have 2 minutes.
Okay, and that would include
21
rebuttal?
seconds.
Okay, so I'm going to make one point. I'm going to make one point, then I'll reserve the rest for rebuttal. What distinguishes her case from the other cases I'm sure your honors are thinking about, including Boast and the Mancini case, the Lake case out of the Ninth Circuit, is that in those cases, the plaintiffs took issue with aspects of elections without ever alleging that those defects were designed for fraud. Okay? They maybe claim that the late arriving vote shouldn't be counted, or that voter registration rolls should be cleaned up. But they could never allege that those defective systems were designed for fraud. And therefore, the only way they could show an injury is if they could show that the use of those defective systems were going to actually cause them to have a poor result. But the courts pointed out consistently, you don't know whether or not counting late arriving ballots or the vote being diluted is going to actually hurt you rather than harm you. You could have most of your supporters vote in these late arriving ballots, and it would help you. But what she's alleging is that, and she says it very specifically, is that all electronic voting machines run the same software designed for fraud, and it's been in use since 2000 and affected the 2020 elections. She's saying, I can't participate in these elections when I know that they're built on fraud. It doesn't matter if they end up getting used to my favor. I don't want to win if it was based on fraud, because that violates my principles.
If I understand your theory of standing here correctly, it's really limited to, in essence, the integrity of voting, right?
Absolutely.
And would not extend, there are many other situations in which, for example, I might be unhappy with the government and I might be very worried about the effectiveness of missile defense shields or about whether the FDA is doing a good job of checking the safety and efficacy of drugs and medical devices. If I'm sufficiently worried about one of those things, can I get an injunction?
No, because you're not participating directly in that process like she is as a potential candidate. And
She's not participating directly.
she has participated since 2016 in the primaries. She's worked in various states doing election poll monitoring, and she planned and expressed interest publicly of serving as a precinct committee person who participates in shaping party policy and selecting candidates. It's something that specifically shows that she's aligning with a particular party, and that is a protected First Amendment right to associate, like the Newcomb versus Brennan case says in this circuit. So she's very much distinguished, Your Honor, from someone who just doesn't like the way our missile defense program works. They're not participating directly in that process. So they don't have a stake in it. I'm out of time. I would
we'll give you 1 minute
respectfully-
for rebuttal.
Thank you very much.
Ms. Shove, good morning.
Good morning, Your Honors, and may it please the Court. My name is Alexandrina Shrove, Assistant Attorney General on behalf of defendants appellees, the Illinois State Board of Elections, and its board members. Malley lacked standing to challenge Illinois' use of electronic voting machines in its elections because she did not suffer an injury in fact that was concrete, particularized, and imminent. Therefore, the district court correctly dismissed her complaint for lack of standing, and this court should affirm that decision. Now, before addressing the 3 prongs of injury in fact analysis, I want to clarify what was and was not Malley's alleged injury here. For the entirety of this case, she has challenged her standing as a voter, not as a potential candidate. She's argued that her injury was the potential for vote manipulation that allegedly could occur because of technological security flaws in the software of Illinois' electronic voting machines. Yet, here today and in her reply brief, she's argued for the first time that she suffered injuries to her constitutional right to association, that her lost confidence in the legitimacy of Illinois elections has caused her to alter her plans to run for committee person or to run for office. In doing so, she's attempted to reframe her injury here as that of a political candidate rather than, challenge her standing as a voter. But the district court couldn't have misconceived her injury below, where she didn't allege a constitutional right to association in her complaint. She did not argue her standing as a candidate in her response to summary judgment, nor did she do so in her opening brief before this court. She's raised this argument for the first time in her reply brief on appeal and at argument today, and as such forfeited any such challenge.
If we agree with you and the day after we issue such an opinion, she files a new case in the district court making those allegations, what happens?
Well,
And
first off,
asserting the candidate theory.
first off, there is potentially a timeliness issue depending on when it was that she intended to run.
Next, that's easy to fix.
There are still many facts that are missing that she would have to allege that simply are not here.
What would they be?
Well, first off, she alleges that her intention was to run for committee person and to run on behalf of a potential set of voters, yet doesn't ever say who those voters are, what political party she's intending to run on behalf of, where she's intending to run on behalf of, or demonstrated any
Okay,
financial...
that all sounds pretty easy to fix, right?
Sure, and if that's the case, then that is a very different case than the one we have here. But we don't have any of those allegations here.
Does the state think that, for example, any candidate, an actual filed candidate, would have standing to bring this kind of a case before the next election to force a change in the system?
Well, I think that's relatively similar to the case Bost versus the State Board of Elections that was recently before the Supreme Court, in which one of their arguments was challenging, if you are a candidate, can you challenge the entirety of your candidacy, any laws that affect that? And I think that if we were to extend your hypothetical, to the fullest extent, that would depend on the decision that comes down from the Supreme Court. But here, not only did she forfeit this argument, but we don't have any of the similar facts that we had in that case. We don't know who she's running on behalf of. We don't have any history of her actually running. We don't have any documentary evidence to suggest that she had intentions of running. And I want to emphasize that in the opening argument, Malley maintained that she alleged that there was actual fraud in Illinois at some point. Now, I disagree with that. As Your Honor pointed out in her opening brief, she explicitly says that her complaint was not based on any actual fraud alleged, but rather on the susceptibility of the machines themselves. But even if we look to the allegations and read them as broadly as humanly possible to suggest that there was fraud in the 2020 Illinois elections, she relies on a report entitled Spiked Voter Report, claiming that there were large dumps of Biden votes in the 2020 election here in Illinois. But that report itself contradicts her allegations in her complaint, because the report itself says, and I quote, "We cannot determine exactly what happened to cause the dumps of votes." And later goes on to say that that report recognized that it could have happened for a legitimate reason. So her own exhibits to her complaint undermine her allegations within her complaint that any actual election fraud happened during the 2020 election.
Who would have standing to challenge this process?
I think conceivably there is a person who could challenge the use of a particular type of electronic voting machine within their district, but I would point out that there are 102 counties in Illinois, and every single county uses a different voting system. And so we have no information about, the various types of electronic voting machines used within the districts here. We don't have any of those allegations. And I think that, to your question, there is feasibly a person within a particular county that could potentially demonstrate standing by challenging the use of their electronic voting machines with more facts that were particularized to the types of machines that were used within their county, and any facts about their county and the process in which they run elections, because every county runs their elections a bit differently. We don't have any of those allegations
I
here.
assume state law imposes some standards on voting systems. Is that correct?
I'm sorry, could you
I
repeat?
assume that state law imposes some requirements or standards for voting systems.
Mm-hmm.
I mean, for example, you're allowed to vote privately, right, anonymously.
Mm-hmm.
Does state law require, in essence, an auditable paper trail of paper or cardboard ballots?
I don't know if there is a law in particular that requires that, but
Or a regulation from the Illinois Board of Elections?
if they specifically require a paper trail,
Yeah, an auditable, something you can recount. I mean, people have been worried about manipulating the software for many decades.
Mm-hmm.
I was involved in some litigation about that more than, well, a long, long time ago. Okay. And the question is, does the system produce ballots that you can recount? And that you're telling me you don't know if that's required or not.
well, I think the first issue with your hypothetical is that we're assuming that all of these machines are the same, and we
It's
don't.
not a hypothetical. I'm asking whether there's a standard across the state that requires an auditable, recountable, physical product from the voting.
Your Honor, I don't have the answer
Okay.
to that question in
Thank
front
you.
of me today, but if Your Honor is concerned about that, I would be happy to submit supplemental briefing to discuss that. Now, turning back to, really quickly, Mally's actual alleged injury here as a voter, she has not alleged that her injury was concrete, particularized, or imminent. She hasn't alleged that she suffered an injury that actually existed. She hasn't alleged an injury, in fact, as a voter that was particularized to her. There's virtually no difference between her allegations and allegations that any voter, either in Illinois or across the United States, could make here. And she hasn't demonstrated that any possible future vote manipulation was certainly impending. She hasn't alleged that any actual vote manipulation occurred, simply that these machines are susceptible to vote manipulation, which again underscores how her claim is not particularized, because she alleges that every single machine is susceptible to manipulation or fraud, demonstrating that her claim is not particularized to her. It is one shared potentially by all Illinois voters and all United States voters. For these reasons, and the reasons stated in our brief, we request that this court affirm the district court's decision below.
Thank you, Ms. Shrove. Mr. Barnhart, we'll give you a minute.
Does that count as I'm walking up?
No, it doesn't.
You can even clear your throat a few times before we start the clock.
Okay. Judge Hamilton, I want to first address the question you posed to opposing counsel. I don't know how there could be a law in Illinois that says that you have to count paper ballots and audits that actually show the vote, because what the Curling versus Rasberger case in Georgia shows, and that's cited extensively in the brief, when they did that extensive study by expert, it starts with an H. Anyways, he said, and some of these ballot marking devices are used in parts of Illinois as well. Same ones that were studied in that case in Georgia. And what the result is that when you make your selection on a touchscreen, it pumps out a paper ballot that purports to contain your vote, but it's all contained in a barcode that you can't read. And then you walk it over.
Well, that's a problem.
That is a big problem, and that's her allegations. Now, we don't know exactly how many counties in Illinois use that, but we know on the record from the Georgia case that their expert says it's used in parts of Illinois. So how could there be a law saying that you've got to be able to audit paper ballots that show the vote when this is in play? I want to go to
Actually, your time is up,
One more
unless the
point?
panel has any additional questions.
Okay.
Thank you.
Yes, thank you
Thanks to
very much.
both counsel in the case, and the court will take the case under advisement. The next case up for oral argument is appeal number 25-1357, United States versus Richards. Morning, Mr. Hammernick.
Good morning. Good morning, Your Honors. May it please the court. Counsel. My name is Jared Hammernick, and I'm here on behalf of Timothy Richards. I'd like to reserve about 2 minutes for rebuttal, and I'll try to watch the clock. In this case, the district court imposed a 36-month sentence following Mr. Richards' revocation of his supervised release. The district court explained that the first reason for revoking his supervised release, well, not for revoking the release, but for imposing the above guideline sentence, was that doing so would provide him with needed correctional treatment in the most effective manner. That's the statutory language of rehabilitation, drawn essentially verbatim from 3553A to D. Because the court relied expressly on rehabilitation as a primary reason for his above guideline sentence, we would ask this court to reverse and remand.
In looking at the totality of the sentencing, I mean, you've identified that one piece, but before that, the court is talking about how Mr. Richards has said, I don't want any more supervised release. I'm not going to comply with the terms. I'm not going to do what you're telling me. Don't give me any more supervised release.
Yes.
In light of that, and the court really grappling with how do I balance then not giving him supervised release but making sure the sentence is proper, why isn't that statement taken in context really a response to that as opposed to a pure rehabilitation statement?
Sure. So I appreciate the question, and I recognize that my client put the district court in a difficult spot in terms of what's the right sentence here. He essentially said, I'm not going to cooperate with supervised release. The court obviously can and really has to take rehabilitation into account when considering different components of the sentence. But 3582A and Tapia are very clear that the court cannot use rehabilitation as a reason for the sentence. And here, what we have is, as the district court's explaining the sentence that it's imposing, the court obviously goes through and lists a number of things that's considering, including, by the way, the government and the probation officer statements that you should impose an above guideline sentence in order to provide him with rehabilitative services. The court mentions all of these different factors that it's relying on, or that's considered, I should say, and then it expressly says, here's the reason for the sentence, right? And it gives two of them. The first one is rehabilitation. And so our argument is not that the court could not consider his, whatever you want to call it, incorrigibility or whatever, in terms of his unwillingness to participate in supervised release. You can consider that, and you may be able to incorporate that in other ways. But what you can't do is sentence him to 36 months of imprisonment, an above guideline term, for the reason that he needs additional correctional treatment in the most effective manner.
Is this a problem simply because of the absence of any further supervised release?
I don't think so. I don't think that's the problem. So in other words, if I understand your question, if the court had said exactly this, but then also imposed some supervised release on the back end, I don't think that this explanation would sort of relate to the supervised release portion, because the court was talking about why it was imposing an above guideline sentence, and the only part of the sentence that was above the guidelines was the prison term.
Well, that's the only part of the sentence, period, in this case, right?
Sure, and so I guess
that's my point, that ordinarily, we've talked before about the cognitive dissonance caused by these statutes and the case law. But we expect the district judge to think about, we require the district judge to think about correctional treatment, right?
Of course.
And so I guess I'm trying to understand if your argument is dependent upon the fact that there was nothing other than prison in this sentence.
I think my argument depends on the record that we have, which is obviously that. And so it's hard for me to imagine. So if the court had provided this exact same explanation in the exact same way, discussed, potential fine or whatever, and then come back around to supervised release and said, I'm also going to impose a 6-month term or a year-long term, whatever, of supervised release, and there was some explanation for that, I think that explanation would relate to the supervised release term. I don't know that you can import an express, explanation for the prison term and say, well, that actually explains supervised release term. I think that would be reading the transcript out of context. But again, we're dealing with sort of a hypothetical transcript, and I understand the difficulty that courts ordinarily have in these cases about sort of balancing all the right factors and walking the cognitive tightrope and so on. And I recognize that, but in this case, we just have a very express statement that I'm sending you to prison for 36 months to provide needed correctional treatment in the most effective manner. That's an express reliance.
Well, if that's all she had said, that would have been a problem, presumably, but yeah, okay. Suppose a district judge looks at somebody in this situation and says, there's just no point in trying to rehabilitate you. Then we'd have a whole set of different problems, right? You'd be here with some very different arguments, right? Under 3553A.
I may. So there's definitely a tightrope here. I'm not suggesting that this is always an easy balance, but what I am suggesting is that 3582A and Tapia are very clear, as is this court's decision in Shaw, and even I think the reasoning in United States versus Long, that there are many things that the court can do in trying to fashion an appropriate sentence, and there are many things the court can say in terms of referencing rehabilitation and trying to reach out to a person in a difficult situation and try to connect with them on a human level. I don't think any of that is problematic. What I think is problematic is imposing an above guideline sentence for the reason that, for a rehabilitative reason, for a rehabilitative purpose.
Why isn't, again, looking at the totality as we must, and we're directed to do at sentencing, it was more than just, I'm not going to add any additional supervised release on here. The court is responding to and grappling with, he has 4 years left on his term of supervised release, which I'm going to terminate. So how do I balance the goals of supervised release, which not only am I not going to impose, I'm going to do away with the 4 years that was originally imposed. It seems like our comment is in response to that.
Sure. I think the sort of history and characteristics as the second reason go more to that. I think, the court was responding sort of in the context of this hearing, and I'm not walking away at all from the context. I think context helps us, right? Because you have a probation officer expressly recommending an above guideline prison term for rehabilitative reasons, and the government expressly adopting and arguing for that as well. So I think the whole context here is like, how do we deal with the individual in front of us and provide him with the help that he needs?
When that happens, why doesn't the defense argue tapia?
I don't know the answer to that question. I think the basic answer is like the government and the probation officer don't violate tapia. The court does when it imposes a sentence, and so.
What
would've
you're
been
telling us is that both the probation officer and the government were inviting the district court to violate tapia. That would,
I think
if
they
that
were.
was so obvious, nobody seems to have picked up on it.
Sure, and so to the extent that goes to the question of forfeiture, plain error review or not, I think this court's case law is crystal clear that.
Well,
standard
it's
review-
not just,
I'm not.
it is not just that, it's also the problem of just how intractable and impossible these tapia issues become.
And I agree in the ordinary course that they can get very, very difficult. I think this is an easy case, frankly, because the court said that the reason for the above guideline sentence was to provide the defendant with needed correctional treatment in the most effective manner. That is the statutory language of rehabilitation. And so from our perspective, we think it's just a clear statement that rehabilitation drove the above guideline nature of the sentence. I'm happy to address any other questions, otherwise I'll reserve the remainder for rebuttal.
Okay, thank you.
Thank you.
Mr. Temkin, good morning.
Good morning, Your Honors. May it please the Court, Eli Temkin for the United States. This Court should affirm Mr. Richards' revocation sentence. I'll start this morning with the standard of review. This Court's review is limited to plain error for two reasons. First, the Supreme Court's recent Asteris case directs courts of appeals to review for plain error in this situation where a defendant does not raise an objection at the sentencing hearing. I'll be happy to talk more about Asteris and the implications here, but more specifically, in this case, the district court asked Mr. Richards' counsel if there was any reason, if there was any problem, any reason the sentence should not be imposed as stated, and Mr. Richards, through counsel, said no. That forfeited the point. So, to recap what happened here, the district court at the hearing heard from the parties, probation's recommendation was out there to clear up. The government adopted, supported probation's recommendation. It did not go into this issue about rehabilitation at the hearing.
When did the defendant have the opportunity to object to this, other than at the end when the court said, is there any reason why the sentence shouldn't be imposed, which we have some case law saying that may not be enough. But when, prior to that, getting at the Rule 51A versus B distinction, did the defendant have the opportunity to object to this issue?
I think there are two parts to the answer. First, the piece that you just referenced, Your Honor, at page 23 of the transcript, page 23 of the appendix, is when this question came up. And asking the question at that point gave Mr. Richards the chance. So it's different from a case where a normal, say, Asteris or Wood or Wiltshire case without that kind of a question. That kind of a question, though, changes the calculation. It gives the defendant a chance to object, and that's what this court held, for example, in United States versus Long, where essentially identical language, the defendant had a chance to object and said no objection. Similarly, in the Salinas case from this court and that Henderson case from the Supreme Court that we cited in the brief, that gave the defendant a chance. The other part of the answer to Your Honor's question is the Wood, Wiltshire, Asteris point. So if there hadn't been a question, the government's position is that Asteris essentially abrogated this court's earlier case law And the government
But
has,
Estera specifically cited 51B and not A.
yes, Your Honor. So Asteris sets out both what happens when a defendant fails to object, but it also explains that the defendant does need to object. And this came up in Asteris because one of the government's main arguments was workability. How is a court of appeals on review supposed to go back and reconstruct what was in the district court's mind? The government presented that issue in its brief. The defendant, in reply in that case, said the answer is plain error review. If the defendant presents the question, then the court has a chance to address it. If not, reviews for plain error. The same issue came up at oral argument. Justice Sotomayor, I believe at page 50 or 51 of the argument transcript, talked about plain error as the answer to that workability problem. Justice Kavanaugh returned to it on page 81 of the transcript. The Supreme Court considered this point and directed courts of appeals to review only for plain error in this situation, even absent a question.
Wasn't Asteris a situation, though, where this issue was known prior to sentencing, or prior to the actual imposition of the sentence? Because I think in the 51B-A context in Wood, and some of our opinions along those lines, the challenge is when the court is imposing a sentence and using a factor that neither side had notice of in advance, that's where 51A comes in, and where you don't have to interrupt the court while the court is imposing sentence at that stage.
Perhaps, Your Honor, but in this case, the defendant had that opportunity. The court on page 21 of the appendix went through its considerations, what it was thinking, and that's where the purported error happened. But the district court at that point had not imposed the sentence. The district court at that point said, the sentence that shall be imposed. Then the district court went through some additional considerations, and on page 23 of the transcript asked the question, gave the defendant a chance, and then at that point said, the sentence is imposed as stated. The defendant had a chance to object. On the Asteris point, the government has presented this argument, as we noted in our Rule 28J letter, in two recent appeals heard before this court. To that point, also, since Asteris, 7 courts of appeals that we've cited in our Rule 28J letter have applied plain error review under Asteris in this circumstance. Asteris, to the extent this court's case law was to the contrary, Asteris abrogated it. Again, though, this court doesn't even need to get to the Asteris point in this case because the question specifically gave Mr. Richards a chance to object, and he forfeited that, consistent with this court's case in Long and the Salinas and Henderson cases. With that, I'll move on to the merits in this case, and the merits in this case actually illustrate what Asteris was talking about, where the defendant is trying to go back and pick out one phrase in isolation without giving the district court a chance to reconstruct, without giving the district court a chance to clarify its thinking on the spot. So that's why Asteris says this is for plain error. The district court's sentencing remarks are considered in context and as a whole, and both parties agree on that principle. The court here relied on permissible considerations and reasons for the sentence, and there is much more to the transcript and to the court's considerations that it set out than my colleague noted. The court on page 21 of the transcript went through all the factors it had considered. It talked about holding Mr. Richards accountable for his violations. It led with that. It said that twice, and that sounds in the breach of trust theory that this court has repeatedly endorsed, just as the sentencing guidelines policy statement endorses. That's consistent with cases like Dawson, for example. The court also talked about Mr. Richards' rejection of supervised release. He told the court that he wasn't going to comply with any future supervised release, and that by itself is a proper reason to revoke supervised release and impose a prison sentence, as this court held in United States versus Smith, and also in the unpublished Gallagher decision. Similarly, it's consistent with this court's Dawson decision that says that expressing contempt for supervised release is a proper reason for a prison term on revocation. The court also considered the fact that Mr. Richards had been given a 6-year supervised release term. He had only served 2 years of that, and he had 4 years to go. He was refusing to comply with any more supervised release. So essentially, he was seeking to get caught early from his original sentence. The language that Mr. Richards points to about this needed correctional treatment, that one phrase did not establish a Tapia error. Again, this is considered in context, and he's seeking to essentially cherry pick this one phrase.
Well, what do you think he was referring to?
It was referring to what to do with this defendant. Everyone was on the same page at the sentencing hearing. He was rejecting supervised release, but he needed some kind of consequence. And so there was a need for some type of correctional treatment, to do something in the correctional system to impose some consequence for Mr. Richards. The district court explained that it was facing this conundrum. The government counsel talked about that conundrum also. Everyone was on the same page. Mr. Richards had no interest in and no appetite for rehabilitation. On a common sense reading, it just would not make sense for the district to think that the district court was thinking about rehabilitation in prison, especially when Mr. Richards said, I'm probably not going to do that BOP programming. That was off the table because of Mr. Richards. He essentially tied the court's hands. To that point, there was no error in the language at all, let alone a plain error, as this court explained in the Long decision, where there was, at best, an ambiguous explanation. Finally, this case does not call for this court's discretionary relief when Mr. Richards rejected supervised release. Thank you.
Thank you. Mr. Hammernick? Would you address the government's argument that Estera abrogates our line of opinions in Wood, etc.?
Sure. So I think the government, this argument by the government is waived wrong and we win anyway, if they're right or not. So it's waived because the argument in the brief was perfunctory and hardly developed. It's wrong because this court, A, has already rejected it, United States versus Stewart. Estera really has nothing to do with plain error review at all. It's dicta about an issue that was not before the Supreme Court. It's considered guidance, and so I think in a 3553 A2A context, this court can seriously consider that, but when we're talking about a completely different issue, I don't think Esteris really guides this court or abrogates it. This court looks for compelling reasons to overturn its precedent. The government has not tried to make that point. And even if the court were to sort of go down that line, I think we still win on plain error review for the reasons we point out in the brief. The error here, we've described at length in the briefing. The error was obvious because the court relied, and let me just quote the court because I think the government really is trying to have this court not take the district court at its word. So here's page 21 of the transcript, appendix page 21. The court says, the sentence is imposed for the following reasons. While it's outside the guideline range, the court nonetheless finds that it provides the defendant with needed correctional treatment in the most effective manner. That's the statutory language of rehabilitation. It's the reason and not just the considerations. Right? The court listed a number of things it was considering and then provided the reason for the sentence.
So are we trying to parse the difference between considerations and reasons?
So when the court tells you the number of things that it has brought into account, I think those are sort of implicit, those implicitly weigh into the balance. But when the court tells you the reason for the sentence, I think that's the reason for the sentence.
You say we should parse that difference and reverse on the basis of that.
I think what this court should do is take the district court at its word that the reason for the above guideline sentence was the reason that it gave. I don't doubt that the court took into account all of those other factors. I submit that those other factors are permissible considerations and in fact likely required. Now some of those considerations I think just underscore the error here, but when the court says here's my reason for this sentence, I think the court should take the district court at its word. And in this case that leads to reversal, and so we would ask this court to do that. If there are no other questions, thank you for your time.
Thank you. Thanks to both counsel. In the case, the court will take it under advisement. The next case for oral argument this morning is appeal number 24-3262, Strickland versus City of Markham. Good morning, Mr. Exline.
Good morning. May it please the court, my name is Jacob Exline on behalf of plaintiff appellant. This appeal revolves around the doctrine of res judicata. Specifically, it resolves the doctrine of res judicata.
Yes. Okay, I'm sorry.
Specifically, three of the elements within res judicata, that being final judgment on the merits, identity of causes of action, and whether there was a full and fair opportunity for the plaintiff to litigate his claims.
Mr. Exline, would you agree with me that no state court reviewed the board's final decision?
Yes, I would agree with that.
Does that seems to me to take this case straight into University of Tennessee against Elliott? The Supreme Court's decision on exactly this problem, holding that res judicata would not apply to Title VII claims, but would apply to the state court and 1983 claims, state law and 1983 claims. Do you agree or disagree with that?
I agree with your analysis that the state court did not review the administrative or the underlying board of review claim. I'm not aware of the Tennessee case and its holdings, but I would.
The university, it's the odd thing about the way this case has been briefed, and I'll be curious to hear from the defense about why there was no mention of it either. It's certainly discussed in the cases that are in your briefs and in the district court's decision, but unless I'm missing something, it looks like it controls here.
I could review that, Your Honor, and provide supplemental briefing on that case specifically. But I think even with the cases that have been discussed, Your Honor is correct and on the right path that because of the analysis of the state court on administrative review, it was merely procedural. It went up on to just.
But Elliott says there has to be a judgment. Putting aside the procedural, administrative, says there has to be a state court judgment
Yes.
in order for the preclusion to apply to Title VII.
And I agree with that as well.
So
There was
what
not a
is the
judgment from the state court.
Right. So under Elliott, if a judgment is required just for the Title VII, I don't know how it could be precluded. This helps you.
Yes, I agree. I
Don't run away from this. Yeah.
No, I 100% agree. And honestly, since that is we're on the same page on that, I'll more discuss the 1983 claims and the Ethics Act. And in regards to those, as we've already stated, there was no final judgment from the state court. That's what the district court stated. However, they did state that there was a final judgment from the Board of Commissioners. But this leads to the first issue on appeal, in that there's no case law or legal precedent where a district court can piece together the different elements of res judicata from different courts of competent jurisdiction in order to preclude plaintiff from pursuing those legal claims. And since the district court found that the Board of Police and Fire Commissioners had rendered that final judgment, that's where the analysis should continue. However, that is not what the district court did. They stated that there was final judgment rendered by the board, but identity of causes of action were found by between the state court and federal court, and a full opportunity was provided by the state court.
I'm not sure I agree with the way you're reading the district court's decision, but our decision in Welch against Johnson seems to make pretty clear that an officer in your client's situation, or a public employee in your client's situation, can raise the federal discrimination points, in essence, in a defensive way in the administrative proceedings. Are you asking us to disagree with Welch against Johnson on that point?
Not asking you to disagree, but I believe there is a distinction. And I think Perella, a Seventh Circuit case, makes that distinction clear. Perella discussed that the board is not a board in that situation. It was discussing whether federal claims, whether there was exclusive federal jurisdiction over the plaintiff's federal claims, and they said no, there's not exclusive jurisdiction. Just like it could go in the state court, you could raise a defense, and they specifically said that they're permitted to raise that defense, but not that they're required to. In this situation, the board doesn't have jurisdiction over federal claims. These are purely just a defense they could make. And it's in saying that, it doesn't create an identity of causes of action. In reality and in practice, these boards don't accept these arguments. They're not trained to discuss complex federal civil theories. In order to entertain the same cause of action and give a plaintiff a full and fair opportunity to litigate their claims only before a board would mean they'd have to determine pretext and understand all these case laws.
Well, look, Elliott is your answer for that, for all of those Title VII points. I don't see where you get any traction on the state law claims here, given the decision to drop the challenge to the board's final decision. But on the 1983 claims, to explain to me what it is about Perella that helps you?
So Perella only states, it doesn't state that you are required to bring this, just that they're permitted, allowed to make this defense if so be it.
Yes, you can do that. You have the opportunity to litigate those issues, which is typically the way that standard is phrased in terms of res judicata, right?
Well, and I would say that litigating those claims before the board is not the same as the board works, is not the same.
Let me go back. You told me that Perella was your answer to Welch against Johnson. Welch looks like a problem for you. So please explain to me why Perella fixes the Welch problem for you.
If I may, Your Honor, let me back up just a step on that and explain on Welch a bit more. Welch dealt with the CSC, and the board here, the Board of Fire and Police Commissioners, it does not have as broad of an action and ability to entertain.
But in Welsh, it was clear the Civil Service Commission did not have jurisdiction to adjudicate the underlying civil rights claims either. And that didn't stop the court from recognizing that they could have raised those as a defense. So I don't think your jurisdictional argument goes to where you want on the 1983 claims.
I understand that, Your Honor. I agree with that assessment.
You are in your rebuttal time if you want to save any.
Unless the court has any other questions, I'll reserve. Thank you.
Thank you. Ms. Shannon?
Good morning, and may it please the court. My name is Colleen Shannon, and I represent the appellees, the City of Markham, and Fire Chief Anthony Mazziota. The district court was correct when it granted summary judgment because all of the claims that Strickland raised in this federal lawsuit are barred by res judicata.
You're familiar with the Elliott case?
Vaguely, yes.
Why doesn't it control the Title VII case and require reversal on those claims?
So I believe that the more recent Seventh Circuit cases, such as Perella, Welch, that have been discussed, Abner is another one. I think they all stand for the proposition that when you did have the prior opportunity to raise your Title VII claims.
Welch distinguished Elliott, you recall, on the grounds that in Elliott, the state agency's decision had not been the subject of state court review. In Welch, it had been. That was the critical difference. Here, I think you would agree there was no state court review of the board's final decision. Do you agree with that?
I don't entirely agree with that. The board's decision, it did go to the circuit court.
Talking about the final decision.
Sure, so the
You
final.
lost on the original decision, right?
the
At least it
ori-
was vacated.
It was remanded for a more detailed finding. And then on the amended decision, that's when Strickland just simply abandoned his
Right.
claims.
So would you agree then there was no state court review of the final operative termination decision?
Yes,
Okay, then why doesn't Elliott control?
well, although the state court didn't issue a final decision with respect to the amended decision, I think there still remains that after a year of not refiling, that determination did become preclusive, and it would operate at that point as a final
The
judgment.
boards.
The state court's dismissal. The dismissal without prejudice, I would argue, became a preclusive.
You think that's a substantive decision with preclusive effect?
After a year passed and Strickland didn't refile his claim, I would say that yes, it does.
What are you basing that on? Because the Illinois courts have recognized that voluntary dismissals do not have preclusive effect.
Correct. However, I believe there are several cases where they've recognized, and actually the district court actually pointed to this in the opinion as well, that it's potential, there was potential for that dismissal without prejudice to have been converted to a dismissal with prejudice after the year.
Sorry, could you please keep your voice up?
Sorry, I'll try to
The microphone
lean
is for
into-
recording, as we have to tell. It's not to
Sure.
amplify.
Sure. After not refiling in that 1 year time period to do so, that it's likely at that point that the state court's dismissal would have converted to a dismissal with prejudice, because at that point Strickland can no longer refile these claims in state court. So
The district court noted, Ms. Shannon, that you all had also argued in favor of dismissal that plaintiff had inadequately pled as to both the role of the chief and the role of the board. Is that right? For a Monell type claim?
that's right. There were several alternative bases for dismissal.
So who other than the chief and or the board would be an appropriate policymaker for Monell purposes?
Well, I believe it would fall on the city itself. I mean, it's someone in a position with the city, but certainly.
And who is that other than the chief and or the board? Is the board's
can't-
decision, does it require ratification by a mayor or a city board?
Yes.
Do they vote on that?
Or no, I apologize.
I don't think so, no.
Right, the board's decision.
They are
with
the
res-
policymakers,
With
right?
respect to the termination and the discharge.
Yeah,
does
okay.
not, yes.
So let me just ask you a more general question here. If I'm a public employee and I believe I've been a victim of race or sex discrimination or retaliation in violation of federal law, and I do not trust local officials to give me a fair hearing on those issues, how do I ensure that I have a right to a federal trier of fact on those claims?
Sure. So that employee, they cannot avoid it if the police or fire board wants to bring charges against them and initiate a hearing against them. And I think at that point, what the employee needs to do is that they need to raise in their defense any potential discrimination or retaliation or any federal claims that they think they might have. They should address those as their defense and present whatever evidence and witnesses and argument they need to do. And then after...
If they lose.
Sure, if they lose, then what Strickland should have done here, if he wanted to be in federal court, is then gone straight to federal court with his federal claims that he wanted to raise. But what he did wrong, if he wanted to be in federal court, is seeking that administrative review in state court first.
But he won that first round, right?
I'm not sure that I would agree that he won.
Well, the city didn't win, right? The court didn't say dismissed, affirmed.
Right. But after the amended decision came through, that's when Strickland decided to abandon the state court lawsuit and in favor of this federal case. But the issue with that is he had that opportunity. He already pursued...
So what do I do? So let me take my hypothetical. I think I've been a victim of violations of federal law. And I also think that the local officials have violated state law. Do I have to choose one or the other? Do I have to split my claim between state court and federal courts? What do I do?
Sure. So he could have brought his claims in federal court if he had state and federal constitutional claims. If he wanted to pursue the administrative review, he had to bring that in state court. And if he wanted to include constitutional claims that are based in federal law, he should have joined those claims with the state court administrative review action. And this court has cautioned that you must do that. If you have related federal claims that all stem from the same termination decision, they have to be joined in that state administrative review action if that's the course you're going. And so because he opted to go that route with the administrative review, then he needed to bring his federal claims if he thought that he had them.
If this case goes forward in federal court on the Title VII claims, would the plaintiff be entitled to take the depositions of board members to inquire into their decision-making process?
Potentially.
I agree.
Would say, yeah.
Okay, thank you.
I just want to address also the Strickland's argument that he was denied a full and fair opportunity to litigate because the board's proceedings were limited, and he claims that the board couldn't entertain his federal claims, and that's just simply misstates the law, which I believe this court has made clear in the Welch case and also Garcia, that due process is satisfied where the party could have raised those claims in the prior proceedings, even if they failed to do so. And here, Strickland certainly did have that opportunity to litigate any of the alleged discrimination or retaliation, first before the board, and then again when the case was with the state court prior to his voluntary dismissal. He was represented by counsel at every stage. He had notice of the hearing before the board. He was given an opportunity to testify in his defense, to present witnesses. He was able to cross-examine witnesses. And then he did take advantage of that judicial review that was available to him. And that's the path that he chose to pursue. Then again, when the case was with the state court, he had ample opportunity to join these constitutional claims in that action. Nothing prevented him from doing so. He simply just elected not to take advantage of that opportunity. But the fact remains that he was able to raise these claims as defenses to the board's discharge, and again, by joining them as claims to his administrative review action. And that's all that's needed to provide the full and fair opportunity to litigate for claim preclusion to apply. So to conclude, the doctrine of res judicata exists to prevent this precise type of repetitive litigation that we've seen here by Strickland. And the district court correctly applied Illinois law and this court's precedent to put an end to this. Strickland had his day in court, and he can't relitigate these same facts surrounding his termination. So for those reasons, we ask this court to affirm the district court's judgment.
Thank you, Ms. Shannon.
Thank you.
Mr. Eckline, you have a little bit of rebuttal time.
Your Honor, Your Honors, Judge Hamilton, I'd like to address your hypothetical that you brought to Appellee's counsel. And what is a police officer or firefighter supposed to do when potentially res judicata could restrict them from taking their federal claims out? And I think that's the whole point and practicality of the argument today, is that the state claim for administrative review was simply a procedural one. It was because the board did not provide any sort of information at all as to why they affirmed, we had to go to state court administrative review and say, we need some information as to why you did this and why you made this claim. There was no discussion of the merits. There was no discussion of facts. And in fact, that's what the order says specifically. Doesn't say anything on the merits, just sends it back down to require more facts. And then when that happened was when we filed for federal court, because we had the facts, we saw what they were, and then we moved on to the federal claims. Same issue can be when appellee discusses joining the case. I think it's a case that they cited that kind of makes that distinction as to why we did not, is Manley versus City of Chicago. In appellee's briefing, they state that 1983 claims can be joined for claims for administrative review. But what that actually says when it goes further into reviewing that analysis of claim preclusion is that it bars federal relitigation of claims argued in state court, but also bars claims that are inextricably intertwined with the state court judgment. The state court judgment here only dealt with the procedural issue of, did the board provide enough facts, and not anything specific as to the merits of the claim. And so joining those claims wouldn't have made any sense there or been appropriate.
Mr. Exline, just very briefly, did the district judge warn counsel that he was about to convert the motion to dismiss into a summary judgment motion?
No, the first time we read that was in the order.
But okay, I take it though that you haven't objected to that procedure.
No.
Okay.
Thank you.
Thank you. Thanks to both counsel in the case. The court will take the case under advisement. The next case for oral argument this morning is appeal number 24-3172, United States versus Barnes. Mr. Baumstark, whenever you're ready.
May it please the court. Good morning, Your Honors. My name is Luke Baumstark. I'm here representing appellant David Barnes. One of the primary issues in front of us today for this case is, must this court take a district court's word when they say what they're doing? Or can it exercise its own judgment and read between the lines as to what's actually going on? Specifically, the question is whether the district court improperly considered a concurrent but separate supervised release matter and/or defendant's juvenile convictions.
Mr. Baumstark, can I clarify, please? Are you arguing that the district court committed procedural error with the guideline calculations, or just that the sentence was substantively unreasonable given that it was above the guidelines and not sufficient explanation?
It is the latter, Judge.
So you're not arguing a procedural error, just a substantive unreasonableness argument?
That is correct, Judge. So if this court can read in between the lines, I would submit that that weighs heavily in favor of reversing this case and remanding it. The district court said that it wouldn't consider the supervised release matter separately. However, if the court looks at what the government actually argued, it specifically mentioned the supervised release case no fewer than 4 times. The court also for some reason that the defense, that the appellant can't understand, pulled appellant's sentencing memorandum from the supervised release case and read that. There's direct reference to that in the sentencing memorandum.
Do you think it's improper for the court to consider the fact that he was on supervised release when he committed this violation?
Not entirely, Your Honor, but I do
Doesn't
think...
that go directly to the court's concern that he was a danger and there was a lack of deterrence?
Judge, I think there is a difference between considering a defendant's priors and sentencing a defendant for a supervised release that is not in front of that court.
It seems to me that the court's concern here with the supervised release was not that the court was sentencing him separately for that violation, but it went directly to the fact that he's on supervised release, he's already served prison time, and he's out committing crimes again. I think the court said, I would think that somebody that had been in jail wouldn't want to ever go back to jail, but you have a history of violating orders of the court to abide by probation and supervision. Doesn't that go directly to lack of deterrence?
I think that statement does, Judge. However, there are multiple reasons why we can see that this was not a standard issue, respect for the law kind of determination. First is that in the transcript for the guilty plea, the court asked the defense counsel whether he planned on consolidating the cases together. When he was informed that it was not defendant's intent to consolidate these cases together, the district court opined that consolidation is proper and that in the district court's experience, this is what has always happened. Then we have the district court pulling the sentencing memorandum from that separate case that was in front of another judge and reviewing that and considering that in the 2024 case. Next, the last thing that this district court judge said before imposing sentence was, you've committed other crimes while you've been on supervision. Finally, if you look at the sentencing guidelines ranges for these separate cases, for the 2024 case, the range was 41 to 51 months. For the separate supervised release case, the range was 30 to 37 months. This district court sentenced this defendant going above the guidelines by over 40% to a sentence of 72 months, which fits squarely within that range when you add them together, the range when you add them together being 71 to 88 months. So the question is, what's the problem with this? Why would this be an issue? And there are several answers to that. First is, if you're being punished for the same thing twice, that's double jeopardy. Second is, it's not a relevant consideration for the district court to be looking at in reaching its decision. The U.S. v. Sims case is one that I cited in my brief, where this court found it was illogical to base a sentence on the potential outcome in another court. Third, at the very least, it violates local rules as to how cases are to be allocated. And fourth, it deprives the defendant of the opportunity to argue what his sentence should be for supervised release.
What happened in the supervised release case here?
The supervised release case resulted in a sentence of 12 months consecutive. So the total sentence between both cases was 84 months.
And that was imposed by a different judge after Judge Gilbert sentenced him to the 72.
That is correct, Your Honor.
Okay.
So
why is that a problem?
Well, Judge, it's a problem because he's been sentenced twice for the same thing. It's not a relevant consideration for the sentencing judge in the 2024 case. Violates local rules as to how cases are to be allocated and how they're to be dealt with. And it deprives...
What local rule is violated here?
Well, all of these courts, Judge, have rules as to how cases are sent out to an individual division. And if judges just start deciding that they're going to pull a case without any further process, that's violative of that rule.
Isn't this a better argument made to the second sentencing judge?
Judge, no, with all due respect, and the reason for that is that the second sentencing judge came in well below guidelines.
Maybe because of what Judge Gilbert did.
That is certainly possible.
Well, what's wrong with that?
Well, I don't have a problem with what the second
I
judge
know
did,
you
Your
don't,
Honor.
but should we reverse the second judge too if we reverse here? I mean, I don't understand what sense this makes. I mean, he can clearly take into account the defendant's conduct and history and characteristics, and he did.
Agreed. However,
but it seems like you're suggesting that because his history and characteristics counts as a different crime, then he can't take it into account, which makes no sense to me.
no, Judge.
If it wasn't a supervised release violation, he could consider it. But because it was a supervised release violation, he can't.
Judge, I think he can consider it, and the guidelines provide for that. The guidelines provided 3 criminal history points for that
Then
crime.
what did he do wrong?
What he did wrong was he shot way over the guidelines by over 40% and did it because the supervised release case was not in front of him.
So that's why your argument is that the sentence was substantively unreasonable
That is
and
correct.
not a procedural problem.
That is correct, Your Honor. Well, looks like I've eaten up most of my time, so what I'd like to do, unless the court has any additional questions right now, I'd like to reserve.
Of course. Thank you.
Thank you.
Mr. Caraway, good morning.
Morning.
Good morning, Your Honors. May it please the Court. Daniel Caraway on behalf of the United States. Your Honor, I'll focus based on the appellant's clarification of why we're here today on the substantive reasonableness of defendant's sentence in the district court. But before I get to the substantive reasonableness, I want to differentiate with what I think the argument in the brief and the argument today isn't very clear. There's this discussion between the judge considering the supervised release sentence that was potentially going to be imposed by another district judge based on comments made at a change of plea hearing. Now, we cited in our brief the lead up to the quote that appellant wrote in his brief as to the court's statements. And when you look at the context of the judge's statements, it was in relation to setting the actual sentencing hearing. When the appellant wrote in his brief, in all the years I've been doing this, usually the same judge does both of them, that was the quote cherry picked out of the change of plea transcript. But when you look at what immediately preceded that, is the court says, "I hereby judge the defendant guilty of violating said offense. Sentencing will be set for November." Then he pauses and he says, "Let me ask you this. There's the revocation before Judge Rosenstengel, and then there's this discussion about potential combining them when he's looking at setting a sentencing hearing." But the final statement that the judge makes, which I think eliminates any argument that the appellant has that there was any improper consideration like in Sims, is the district court says after Mr. Baumstark, who was the trial counsel below, says that he was not going to consolidate the cases, Judge Gilbert says, "I will give him a sentence irrespective of what my knowledge is of the revocation." And then Judge Rosenstengel, who was the district judge that had the supervised release case, will do her own thing on the revocation. Your Honor, I think, and as Judge Kirsch mentioned, I think it's absolutely a proper consideration for the district court to consider the fact that Mr. Barnes was on supervised release for a drug trafficking offense in which he served 300 months later, I believe, based on some retroactive amendments to the guidelines, was reduced to 189 months. But that was a significant focus of the government's sentencing argument. The focus was not what the potential sentence is going to be on supervised release, but it was the fact that this defendant received what was later reduced to a 189-month sentence He was released on supervised release and immediately went back to distributing controlled substances. I certainly think that's an appropriate consideration for the judge. There's this other argument that was mentioned today. It's highlighted more in the brief as it relates to these juvenile convictions. The appellant has raised in this court, just as he did in the district court, that basically those juvenile convictions, because they did not receive criminal history points, should not be considered at all. These procedurally it was a little bit different. These were actually adult convictions that after Mr. Barnes served a period of imprisonment were later voided and entered as juvenile adjudications. But based on the age of those, obviously he served an extended period of time in the Bureau of Prisons. The 2 juvenile adjudications for robbery with a firearm and aggravated discharge did not receive criminal history points. What he's asking the court to do is just ignore them, as he asked the district court to do, which is contrary to this court's holdings in McIntyre and Cunningham, where we're not bound by a criminal history number that the guidelines spit out. There are certainly considerations on if the district court determines that a criminal history category either overrepresents or underrepresents an individual's criminal history. And if you look at the sentencing transcript, that's exactly what Judge Gilbert and the district court did. He went through defendant's criminal history. He said that he may be one of those people that simply cannot conform to a law-abiding life. If you look at the transcript, there's multiple pages on pages 58, 59, and 60 where the district court talks about continued criminal offenses while under previous court orders, that being most recently while under supervised release. He talks about the need for deterrence and the statement that I believe Judge St. Eve mentioned, that an individual that served a 300-month sentence, the court would think that he would not want to return to a term of imprisonment. Despite that sentence, he went right back to dealing. That was on page 59 of the transcript. And then on page 60, the court goes into, thinking about McIntyre and Cunningham, found that the criminal history category underrepresented his criminality and seriousness of his criminal conduct and believed that the above guideline sentence was warranted. He looked at that sentence. He found that this was an individual who had a prior conviction for robbery with a firearm, prior conviction for aggravated discharge of a firearm after he shot at a victim. He had multiple marijuana-related convictions for fleeing and eluding law enforcement, and then the 2009 federal drug conspiracy conviction. There was an imposed 300-month sentence, later reduced to 189. The court noted, and I think as Judge Kirsch mentioned, Judge St. Eve mentioned, he was on supervised release for a drug-related offense when he began dealing again. Certainly something that would indicate a variance above the guidelines was appropriate. The appellant today has disclaimed any procedural error by the court and has rested on a substantively unreasonable attack to this defendant's 72-month sentence. Your Honor, the government would contend that certainly his sentence is reasonable in reviewing those 3553A factors, as Judge Gilbert did on the record in the district court. A 72-month sentence, which is a variance above the guideline for a now 2-time federal convicted drug dealer and an individual with multiple violent offenses, is substantively reasonable. And unless this court has any questions, the United States would ask the court to affirm the sentence imposed by the district court in all respects.
Thank you, Mr. Carraway.
Thank you, Your Honor.
Mr. Baumstark, you have a little bit left.
Thanks very much. I'm going to try to go quickly here because I have a little more to say. First, if the court had actually done as the government suggests and based this sentence just on disparities with the defendant's criminal history, why didn't it say that in the statement of reasons? There's a box right there for the court to check. It did not check that box. It checked the government's motion for variance and to reflect seriousness of the offense, promote respect for the law, and provide just punishment for the offense. If we break those down very quickly, The seriousness of the offense. This was a garden variety sale of cocaine. There was nothing particularly egregious or aggravating about it. As to providing just punishment, the same thing applies. What the court was really getting at was promoting respect for law and to protect the public from the future crimes of the defendant, which it reached by looking at the government's motion. The government's motion, if you track it through, argues the supervised release case, juvenile history, returns to the supervised release case, makes a throwaway line about whether the defendant was willing to also sell methamphetamine, and then returns back to the supervised release case a third time. I would submit to the court that unless this district court gave an upward variance of over 40% because a known drug dealer expressed a willingness to sell drugs, then the real reason why it ranked over 40% is because it was sentencing him for both the 2024 case and the supervised release matter.
Thank you, Mr. Baumstark. And Mr. Baumstark, I understand you've been appointed in this case. Thank
That's
you for
correct.
your service to your client and to the court.
Thank you very much. I appreciate the court's patience this morning.
Thanks to both counsel in the case. The case will be taken under advisement. The next case for oral argument this morning is appeal number 25-1018, Brogsdale versus Torres Corona. Good morning, Mr. Lubin.
Morning, Your Honors. May it please the court.
Just 1 second, please.
Sorry. Morning.
Okay.
Champing at the bit.
You go right ahead.
After 3 coffees, my apologies. May it please the court and counsel. Imagine a scenario in which one man walks up to another in the street and he says to the man, "I'm going to hurt you, I'm going to physically hurt you." And then he pulls his hand, says, "I don't know you, I just feel like hurting you." He pulls his hand back, he goes to punch. And the other man defends.
Where does the complaint say that?
The complaint says not that, but something relatively simple.
Isn't that a problem though? Because the complaint doesn't say anything at all about immediate harm or the necessity for use of force.
It discusses the actions. All that we have is what happened, and it discusses the actions that Mr. Reynolds was
But
taking.
is that what happened? I mean, what you just described, is that what happened? That he pulled his arm back and he was ready to hit him, and then your client punched the
He was rushing the...
Mr. Reynolds?
Yes. In fact, the line is, he was screaming, and I've seen the video of this. The video is rather stark, but we never got there in the case. Reynolds is standing up a flight of stairs, looking down. The police are standing there. They're trying to calm him down. He's not listening to anything they're saying. And Reynolds is saying, "I got you. You're going to see about me. You're going to feel me. I got your ass." He says these things, not to the officers, he says it to my client, to Mr. Brogsdale. They're telling him, "Calm down." He's not paying any attention to him. He rushes past one of the officers. The second officer is next to my client. Neither of the officers do anything. My client is standing on the threshold of his home, and he puts his hands on Mr. Reynolds in order to prevent him from getting into the home. And all of that is almost objectively textbook a case of self-defense. And the purpose of the hypothetical, which is different from this case, but it's to isolate what the legal argument really is, because what the district court found is that in that hypothetical, whereas very, very clearly, according to everybody, a case of self-defense, if a police officer shows up on the scene after the first punch is thrown, or if the police officer watches the entire incident, including the threats, according to the district court, the police officers have seen the exact same scene, at least as far as the law is concerned, because the district court's ruling was that when you look at whenever the reason for innocence is an affirmative defense, in this case self-defense, that ends the inquiry. An affirmative defense could not possibly be the underlying factor in a 1983 suit. And that's not the law. That's not what this court has said the law is.
Mr. Lubin, can I ask you, and I'll want to ask the defense as well, this. I've been trying to think about this case. Suppose it had spun out a little bit differently. And we have the factual allegations in the complaint about what Reynolds did, about his threats, and his refusal to comply with the verbal commands to stop. At that point, would the officers have been justified in using force against him?
Absolutely.
I tend to agree with that. And if they don't, it's a little hard for me to understand why Mr. Rogsdale can't take action to defend himself.
I agree with exactly that. If Mr. Brogsdale was a police officer, happens to be he is a police officer, but it doesn't really matter. If he's a police officer standing in that circumstance, I don't think there's any question the police officers would have had a right and a duty to step, not a legal duty, but at least a moral duty to step in and stop a violent act from taking place.
Certainly a right to do so.
Certainly a right to do so. And probably more relevant in this room, they have a right to do so. You know, they wouldn't have been arrested for preventing this violent attack. And so for the very same reason, my client, if he was a civilian, really should have the same exact right. And the important thing in this case, well, one of the important things in this case, is that the police officers who arrested Mr. Brogsdale witnessed the entire thing. In other words, they not only witnessed my client place his hands on Mr. Reynolds, they also witnessed the lead up to that, which gave way to the defense of self-defense. This court, in several cases, has ruled that when the officers witness the self-defense, or not the self-defense, when they witness the affirmative defense, that must be part of the probable cause analysis that the officers engage in real time.
Right, but it must be conclusively established that the affirmative defense applies. I mean, beyond a doubt that self-defense applies. It's different than when you're arguing self-defense in a criminal court and you're the defendant, than when you're the plaintiff suing the police officer saying that it was beyond dispute that the defense of self-defense applied.
I don't think
right?
I've seen language, and I don't know that it changes the outcome here, but I don't think I've seen language that says it must be conclusively established, it must be proven, you know.
You haven't. Isn't that the standard?
The standard is when making a probable cause determination, simply alleging the affirmative defense doesn't undermine probable cause because the arresting officer has no duty to investigate the validity of any defense, but, and that's from Hodgkins, but when the officers see the actions which give rise to the self-defense, they can't ignore it. They're not permitted to bury their heads in the sand.
There's, at trial, probably the language of the instructions would need to be something close to conclusively established, right? It should have been obvious to the officers at the time.
Should have been obvious to the officers. I don't know if I'm conceding anything by conceding that, but certainly at the pleading stage, I don't know that I need to plead the facts that demonstrate it was conclusive, obvious. There's not any possible other conclusion. But perhaps when writing up the jury instructions, there could be some language that shows a heightened burden. I don't know because
I mean, look, I think we all recognize officers often step into the middle of situations where it can be very hard to tell where responsibility lies. And I understand your case here to be unusual because you're saying the officers saw the whole relevant sequence.
Correct.
But those jury instructions will need to account, in essence, for the broader kinds of problems that officers face.
Of course. But that's what makes this case interesting. A lot of the decisions, in fact, every single decision I believe that was cited by the district court in justifying this order was a circumstance where what the officers knew at the time that they made the arrest was that the crime had been committed, and they were not aware of the facts that led to the affirmative defense. Had they been aware of those facts, the analysis may have been different. And the only one which doesn't fit into that pattern is Bayless versus City of Chicago, which, as I've written in my brief, I don't think was correctly decided.
There seems to be some tension with our cases that it's clear officers, once they have probable cause, they don't have to do anything else to investigate a potential affirmative defense.
To investigate, correct.
And so there seems to be some tension with that in your argument that you could conclusively establish at the pleading stage that there was self-defense going on, and they should have known that.
I don't know that it's a tension. There's two cases. If the officers come onto a scene and they don't know anything other than that a crime has occurred and they're not aware of the affirmative defense, then that's it. There's probable cause. They're not going to be liable. But if they know everything that happened, if they witnessed the entire scene, the fact that the reason the defendant isn't guilty is because of an affirmative defense, that has to play into their analysis. They're not able to bury their heads in the sand. I think that language is used in at least one of the decisions. I believe it's Humphrey off the top of my head. I see that I'm at 2 minutes. I think I wanted to take 3, so at least I'll take 2.
Okay, thank you.
Thank you, Your Honors.
Ms. Bernier?
May it please the court. Brogsdale's false arrest claim was correctly dismissed. The allegations in the complaint established that the officers had probable cause to arrest Brogsdale for battery, and Brogsdale's assertions about self-defense don't negate that probable cause. According to the complaint, the officers observed Brogsdale commit a battery against Reynolds. The complaint alleged that in the officer's presence, Brogsdale placed his hands on Reynolds, and Brogsdale described that act as a use of force. That was contact of an insulting and provoking nature, and Brogsdale does not claim otherwise. So all of the elements of a battery were met. Brogsdale's claim that he was acting in self-defense doesn't negate that probable cause. To negate probable cause that Brogsdale was acting in self-defense had to be obvious to a reasonable person in the officer's position. To put it another way, that Brogsdale was acting in self-defense must have been staring the officers in the face. And I think...
Why wasn't it?
Pardon me?
Why wasn't it? Based on the allegations in the complaint here.
Sure. So
Would you agree with your friend on the other side that the officers, based on the facts alleged in the complaint, would have been justified in using force to prevent Mr. Reynolds from attacking Mr. Brogsdale?
No, I don't agree. The officers, based on what the allegations that are in the complaint, the officers would not have been justified in using force. What we have... He
was threatening. He was disregarding verbal commands, right? I'm trying to remember what I know about the continuum of the use of force, but we've gone beyond presence. We've gone to verbal commands. Don't we next go to so-called soft hands?
Well, so what we have that the officers actually saw in the complaint, and again, it has to be obvious to the officer, there can be absolutely no other conclusion that can be drawn, is we have these vague allegations about Reynolds being drunk, yelling, and
What's vague about that?
That they don't show that Brogsdale was obviously in imminent physical peril. He
was being threatened by a man who seemed to be trying to invade his apartment, who was disregarding verbal commands from police officers to stop. Do they have to wait until a punch is thrown?
There needs to be more. Based on
what
this,
more?
For example, a punch was about to be thrown, a weapon, something else other than this vague collection of things that keep changing as more filings get produced. So today we hear that now he's on the threshold. That's new. So it is not enough.
This is all on the pleadings, right?
Correct.
And the plaintiff is entitled to elaborate on pleadings, on factual allegations that are consistent with what's alleged in the complaint.
Correct.
So I'm trying to understand what was fatally missing from this.
They only knew what they could absolutely observe. Charging could mean many things. The threats, this is a drunk person. The officers were there. They were able to see exactly what Reynolds
So shouldn't we just hear testimony from the people who were there about those kinds of details?
That's not necessary because this collection of allegations does not make it completely obvious that that Brogsdale was obviously in imminent physical danger. This is just based on it has to be plain as day. And the only thing that was plain as day from the officer's perspective was that Brogsdale had committed a battery. Self-defense is a 6-part test. It hinges on the beliefs of two people. And no case requires officers to ferret out in the middle of a dispute what everyone is thinking. They are allowed to act on what they can actually observe and leave competing inferences about mental states and whether defenses apply to the rest of the law enforcement process. They don't have to dissect an altercation and look for evidence. They're allowed, based on what they saw, to arrest both Brogsdale and Reynolds and let other aspects of the law enforcement process sort out the evidence.
What was Reynolds arrested for?
Criminal damage to property.
Can you give me your best legal authority for the pleading requirement that the district court applied here?
Sure. So I would say that Hodgkins is the best.
Hodgkins?
Hodgkins, because it sets out, I know it's not a motion to dismiss, but it clearly sets out what it means to be obvious. And it means that the officer needs firsthand knowledge that the behavior fits the defense. No
Yeah.
other,
Okay,
yeah, so it needs to be plausible.
plaintiff likes that case.
I'm sorry?
Plaintiff likes that case.
Sure, we like it too. I mean, because it explains exactly how obvious it needs to be. And with respect, I believe that plaintiff is misinterpreting what the import of Hodgkins is, because I think Hodgkins really lays out exactly how clear it needs to be to the officer that there's an affirmative defense. That if the officer, in that case, the example was there was a curfew law and there was an exemption for minors who were coming home from protected
Right.
activity, right? So if there's a teen that was stopped by an officer after whatever the curfew time was, and the teen said, hey, I was coming home from a rally, the officer does not have to take the teen at her word.
Right.
Yeah.
But
so,
if the officer sees the teen leaving the rally, the officer has to take that into account, right?
correct.
So why doesn't this all just turn on factual questions under the umbrella of these allegations in the complaint?
Because it's not plausible that it was obvious to the officers that
What's
Rosdell
not,
was-
okay, I'm having trouble understanding what's not plausible about that. Because it seems to me pretty obvious that if the officers had used force to stop Reynolds, the city would be in here having no trouble defending that use of force.
then
But here it was an off-duty officer who was using the force.
the reasonable inference is that the off-duty officer was taking matters into his own hands when he should not have. That there were two officers there.
Who were doing nothing, according to his complaint, other than issuing verbal orders that were being disregarded, right? Those are the allegations in the complaint.
What Reynolds was presenting, based on the complaint, did not put Brogsdale in imminent physical danger, that he was about to get physically harmed, and there would have been no way for the officers to know what Brogsdale was thinking. And based on what they saw a
If the
battery.
complaint, it included details like Reynolds was approaching at, let's say, 3 feet per second with a fist raised and was 18 inches from Mr. Brogsdale. Would that be sufficient? Is that what we should expect from a complaint in this case?
I mean, that would be better. I'm not.
You don't think that would be enough?
It would depend on.
You're not
what else-
willing to concede that?
It would depend on what the other allegations are.
Everything
This-
else is the same?
Everything else, and he's coming at 3 feet, you said 3 feet per second.
Yep.
That at least, and he had a fist
Make it
raised.
10 feet per second.
That would be, yes, that could be enough, but that is not what we have here. What we have here is a drunk guy who is yelling and advancing from an unspecified distance, and the officers clearly saw.
Past the officers, right? Past the officers who were between the two of them.
Past one of the officers.
Oh, okay.
Yeah, so there are two officers. At one point, they were separating the both of them.
This sounds a lot to me like a pretty good jury argument.
That's, our position is that this was correctly dismissed because it is not plausible that it was obvious to the officers.
Okay. I understand your position. So.
Okay. If there are no further questions from the panel, we believe that the district court judgment was correct, and we ask that the judgment be affirmed.
Thank you. Mr. Lubin.
Thank you. The criminal damage to property, by the way, was the fact that Mr. Brogsdale's door had been beat in so badly.
What does that have to do with imminent harm?
Well, it has to do with what the officers know. It's one of the
Right,
many
it
things.
doesn't have anything to do with whether Mr. Brogdale was in imminent harm.
the imminent
It has
harm-
to do with property damage.
Correct. The imminent harm is the fact that Mr. Reynolds is advancing at him and is threatening him while he's advancing at him and is ignoring the police officer's command while threatening and advancing at Mr. Brogsdale.
Was he advancing from 100 yards?
He was, well, I mean, I'll tell you, he was advancing from up a small flight of stairs. I don't know that
Would it have made a difference if he was 100 yards away and advancing?
if he got to within reaching distance of Mr. Brogsdale, he's no longer at 100 yards.
What if Mr. Brogdale shot him from 100 yards?
Certainly that would be different. Yeah, that would be different. That would be a very different story.
Where does your complaint say that it was imminent? Which paragraph should I look at?
Where he says that he was running at him and he passed one of the
Doesn't say
police
running.
officers.
It doesn't say
He was
that.
approaching at him while threatening, and he passed a number of police officers. And
He
if
passed
the question
one
is,
officer. who told her to stop advancing. He said, nah, 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 I do not want. I do, nah, nah, nah.
Correct.
And then it says, Brogsdale prevented Reynolds from harming himself or anyone else by placing his hands on him. Where's
Correct.
the imminence?
The imminence is that he was close enough to do that. If he wasn't close enough to do that, then he wouldn't have been able to do that. At this point, Reynolds has passed one police officer. The other police officer is doing nothing to stop him. And I think the question, would a police officer have been allowed to put his hands on Mr. Reynolds? Certainly so. And there shouldn't be really any difference.
Well, maybe not. Maybe Reynolds would have sued. Maybe Reynolds would have brought a 1983 claim against police officers, right? You see the predicament they're in?
I wouldn't have.
And then maybe they get their trial. And they get to tell the jury what they think.
Could be, and that's part of it.
Could
really.
be, right?
It's a jury question. It's a fact.
It's not
question.
always a jury question.
No, but in this case, it is. I mean, the case on the pleadings standards, by the way, is Swanson v. Citibank, which says that the required level of factual specificity rises with the complexity of the claim. This is not a complex claim. It doesn't require discussing feet and feet per second and all of that. The last thing, I realize my time is out. The term in Hodgkins, by the way, is knowledge of the facts and circumstances which would conclusively establish the affirmative defense. That's the language to answer your Honor's question.
Thank you, Mr. Lubin. Thanks to both counsel.
Thank you very
Court
much.
will take the case under advisement. The next case for oral argument is 24-1844, United States versus White. Good morning, Ms. Gambino.
Good morning, Your Honors. Judge St. Eve, Judge Hamilton, and Judge Kirsch. There are two issues before the court this morning. The first is whether a non-negotiable appellate waiver violates the Constitution and creates a miscarriage of justice.
Why was it non-negotiable?
Because the government would not permit the plea to be entered without the...
Oh, no. The government would not agree to a plea agreement. She could have pled guilty, and then she would have had her right to appeal everything that she wanted to, right?
She could have pled guilty without a plea agreement.
Right, so what's non-negotiable here? Where do you have a constitutional right to a plea agreement?
You don't have a constitutional right to a plea agreement, but when you're talking about a negotiation between a defendant and the government, the power differential is huge.
Does that make it unconstitutional?
It makes it unconstitutional when the defendant really doesn't have a choice.
Well, the defendant does have a choice. She has this following choice. She go to trial and win a trial. She go to trial and lose a trial. She can plead guilty without a plea agreement. The government never has to offer a plea agreement, and they don't have to offer terms that she likes.
That's true, but when there is a plea agreement and one of the parties is not permitted to negotiate over that particular provision, then you have.
What if the government says, in a different kind of case, we have to have prison time? That's not negotiable. Does that make that plea, for example, in a white collar case, unconstitutional?
I believe that the standard for the defendant is whether they are knowingly and voluntarily entering into a plea agreement. Yeah. And when there's a term which they cannot negotiate, then they are not voluntarily entering into the plea agreement.
What case law says that? If the plea agreement has to have consideration because it's a contract.
Correct.
And there are agreements that the government agreed to here in order to negotiate, and she got the plea agreement, and the government got these various provisions that it wanted. So I'm not aware of any law that says if a defendant wants to negotiate a different provision and the government says, well, no, we're not going to agree to that somehow that's not knowing and voluntary. That's just the government not agreeing to that particular consideration.
This is a particular situation with Ms. White in which there wasn't identifiable consideration.
What about the government's agreement to recommend a low-end sentence?
The government agreement to recommend a low-end sentence.
That's consideration.
That is some consideration.
That's consideration. Our case law makes that very clear.
But it is not to require that she give up a right, a substantial right that she has. and leave her without recourse when things are substantially unreasonable at the end of the day, leaves her with no respect for that particular right. And when you're talking about
That's not a knowing and voluntary argument. That's a we don't like the sentence argument, which you could challenge if you hadn't waived.
Well, if you render the right to appeal non-negotiable from the point of view of the government, from the point of view of the defendant, then there is no option. Then you're saying that you have to give up this particular constitutional right in order to go forward. And
so your argument is that the government has to sit down with the defendant in a plea agreement, and anytime the defendant wants to put a particular provision in, that the government has to agree to that, or somehow there's no consideration?
No, what my argument is that when you're talking about a valuable constitutional right, such as the right to appeal from a sentence, that the government should not be able to foreclose that in the course of their negotiation because they hold the entirety of the
You're
of the
saying
balance of power.
foreclose it. They rejected it. That given it looks like, given the underlying conduct here, they agreed that she would get a reduction, or they would recommend to the court that she get a reduction for acceptance of responsibility, agree to a low end of the guideline sentence, but waiving the right to appeal was part of that quid pro quo in the contract.
The quid pro quo, the essential quid pro quo was that she was going to enter this plea. And the government, in my argument, is that they should not be permitted when it comes to the right to appeal in every case to require that this is a non-negotiable term.
Do you agree that if the waiver applies here, that your appeal falls within it? So if the waiver applies, you cannot appeal whether or not the sentence was substantively unreasonable?
If the waiver applies, and of course I disagree that the waiver applies not only for the violation of the constitutional right aspect of it, but the ambiguity of the waiver itself. Certainly it is not drafted with the utmost clarity. They're talking about contesting all components of my sentence or the manner in which my conviction or my sentence was determined or imposed, which does not refer to specifically to what happens within each component. You can't contest the component itself, but it doesn't refer to the term of the sentence, the amount of the restitution, whether there is going to be a fine or something of that nature. So I think that also is something that needs to be considered in this case.
If we're considering the facts of this case, it's hard to imagine a defendant better situated to understand what that language meant. Had she completed her dissertation in her PhD in criminology?
She had not, Judge.
Okay, but she had the master's and
She
was
did
working towards the PhD.
That's correct. That's correct. She had no experience with the criminal justice system, however. And what I'm asking for with respect to the appellate waiver is that the circuits are divided as to whether there is sort of a safety valve and when there's going to be a miscarriage of justice or when there is a serious issue, that there's an analysis that the First and the Second Circuit go through to determine whether they should apply that safety valve.
What is your miscarriage of justice argument? The circuits that have adopted that apply it in pretty extreme circumstances.
And we've made pretty clear, if I could just add, that for example, we won't enforce a waiver if the district judge has sentenced above statutory maximums or it's clear that race or sex or some other clearly improper consideration has come into play.
Exactly, which is what these other circuits have determined miscarriage of justice. Your miscarriage of justice just seems to be the sentence was substantively unreasonable.
Which is a serious, in the circumstances of this case, that is a serious consideration because what occurred in this case was not only the interests of the single defendant in this case, but her children. 3 of the children were the children of both she and one of the principal actor in this case. So it's substantively unreasonable not to give consideration to the fact that the sentences imposed, both with the father and the mother, are essentially rendering these children without parents who are going to be able to be active in their lives, in one case ever, and in her case for all of their young lives until they're adults themselves, and imposing another burden, a serious and significant burden on other individuals to take care of these children. And when you balance that against the fact that she had no prior criminal involvement, that she was a victim of spousal abuse by one of the perpetrators of the action, and that she had the least significant role to play amongst all of the players here, and that the two other co-defendants who actually participated in the robbery where she did not were sentenced far less time than she was, without any of those mitigating factors, and with the only mitigating factor being that they had testified against their co-defendant.
They cooperated and entered a plea and testified. That's very different than comparing to a defendant who proceeded to trial.
That's true. Ms. White did not proceed to trial.
Or who didn't have that cooperation.
She did not cooperate. The other two did. But to give them the degree of break which they got, given the seriousness of their conduct in comparison to her role in the offense, even that cooperation doesn't account for the disparity that we're talking about.
Do you want to save your little bit of time?
I do. Thank you.
Thank you. Mr. Temkin, welcome back.
May it please the court. Good morning again, Your Honors. Eli Temkin for the United States. This court should enforce the appeal waiver and dismiss.
Why didn't the government file a motion to just enforce the appeal waiver in this case?
The government could have. This court has given different views on when a motion to dismiss right off the bat is appropriate. This is a big case. It's a significant case. The offense conduct is tragic. It's a weighty sentence. The government thought it would be prudent to brief the case and present it to the court, but it very well could have moved to dismiss. The appeal waiver covers this. This is well within the scope. The appeal waiver by its terms covers all components of Ms. White's sentence or the manner in which her conviction or sentence were determined or imposed to any court on any ground. This falls squarely within. This is about the length of her sentence and its substantive reasonableness. This court has held that the length of the sentence is a component of the sentence, which is a common sense reading, consistent with this court's cases that we cited in Uriarte and Block. The Lockwood case we've cited as well makes clear that that same language covers a great deal. The appeal waiver is enforceable and valid here. It was knowing and voluntary. Ms. White repeatedly said that the agreement and the plea were knowing and voluntary. She acknowledged that she was giving up the right to appeal, even if the sentence was harsher than she expected, and she understood the statutory sentencing ranges that she was facing. So there was no clear error for the district court to find that the plea and the agreement were knowing and voluntary. Ms. White's arguments now don't give any reason to doubt that validity. The plea agreement as a whole was negotiated. She had choices here. She could have pled in the blind, she could have gone to trial, and she chose not to. The plea agreement is valid even if the government is not willing to negotiate on one particular term. The agreement as a whole still can be valid, as this court has explained in cases like McGuire and Hare that we've cited. Ms. White received consideration. The government recommended a sentence at the bottom of the guidelines and the offense level reduction for accepting responsibility. And even now on appeal, Ms. White says that she entered the plea agreement hoping to avoid a life sentence. She said on page 16 of her brief, and she did in fact avoid it here. That was the bargain that she struck. This court has rejected the idea of this amorphous miscarriage of justice exception. The court has stuck with only narrow exceptions that wouldn't cover this situation, and there's no reason to overturn that precedent.
Those exceptions don't seem any different than the miscarriage of justice exceptions from other circuits. Those are pretty narrow.
I think that's a fair reading, Your Honor, and that, if anything, just says that those circuits, whether they call it a miscarriage of justice or something else, aren't adopting this kind of amorphous exception. In practice, it seems like those circuits are consistent with this court, only actually applying these narrow, limited exceptions. Even if there were some amorphous exception, this is not the case to find a miscarriage of justice, which gets to why the sentence was substantively reasonable. Ms. White received a below-guideline sentence. This court presumes it's nearly an irrebuttable presumption that a below-guideline sentence is reasonable. This court, to the government's knowledge, has never found that type of sentence to be substantively unreasonable. In this case, the court appropriately weighed the statutory sentencing factors. The offense conduct was grave. It involved a bank robbery with a murder of a recently retired police officer. Ms. White was a full and active participant. She planned it. She convinced one of the robbers to join. She stood to get some of the money. She provided the guns. She had downloaded the scanner app, and she served as their lookout. And then after the robbery, she sent the driver to go pick up the robbers. She didn't come clean or withdraw, and she just kept helping her fiance, who was the one who pulled the trigger. The factors that Ms. White points to now in mitigation, the district court accounted for in imposing a sentence that's almost 9 years below the bottom of the guidelines range. The court recognized the weighty burden on her children, but it also recognized that Ms. White brought that on them, and there's no less of a burden to the victim's family. Any disparity with her co-defendants was warranted because they cooperated in the case and testified against the person who pulled the trigger. For all those reasons, unless the court has further questions, the government asks the court to dismiss the appeal or affirm.
Thank you, Mr. Temkin. Ms. Gambino, we'll give you a minute.
We're not talking about an amorphous exception here. What we're talking about is something similar to what the First Circuit does with the teeter test, which is to look at whether the scope of the waiver is clearly delineated, whether the district court specifically inquired of the defendant, and would the denial of those rights constitute a miscarriage of justice. And in this particular case, given the circumstances surrounding the offense and Ms. White's personal circumstances and those of her children, a sentence of 25 years was substantively unreasonable, and if you look at each provision of the teeter test, it would weigh in favor of finding that exception in Ms. White's case. So we would ask that the court reverse and remand.
Thank you, Ms. Gambino, and you accepted appointment in this case.
I did, Your Honor.
Thank you for your service to your client and to the court in doing so. Thanks to Mr. Temkin as well, and the court will take the case under advisement. Our last case for oral argument this morning is appeal number 25-1411, United States versus Cornelius. Good morning, Mr. Stevens.
Good morning, Your Honors. May it please the court. I want to start with one of the things that I think is a sub-issue in this case, and that is whether the district court's determination concerning self-defense was procedurally unreasonable. We have the law is pretty clear that once a defendant raises an issue of self-defense, the burden shifts to the prosecution.
That's as a matter of Indiana law?
That's a matter of Indiana law. I cite that proposition on page 22 of the opening brief. The district court looked at, first of all, the record is clear that the attacking vehicle came around the block past Mr. Cornelius's home, or the place where Mr. Cornelius and his family were. And then came around again, and the occupant, or one of the occupants of the car, started shooting. Mr. Cornelius retrieved the gun from one of the other family members and started to shoot. The gun jammed initially, but then he pulled the slide back and was able to fire the gun. The assailant either got back into the car or started to drive away, and it was unclear whether they were going to come around the block again or whether...
How do you get around the fact, on your self-defense argument, that your client admitted that as they drove away and the threat was no longer there, he kept shooting at them?
Because the threat was there, he had a reasonable belief that they could shoot out of the car at him.
But they weren't shooting out of the car, they were driving away. And he kept shooting, even though they were driving away.
They had the capacity to shoot back at him.
But
I mean, that's where his...
If the threat to you subsides, but you continue shooting, that's no longer self-defense.
But the question is whether he continued to have a reasonable fear of death or great bodily harm. And once it is not clear that the attack was over simply because they were driving away. They had the capacity to shoot back at him.
And that's an argument that you made to the court, but how was the court's factual determination clearly erroneous when it found, based on that there was no longer a reasonable fear because they were driving away and not shooting while they were driving away?
Because of the prosecution had the burden of establishing that the fear had dissipated, and the simple fact that the attackers were going in a different direction didn't diminish that fear. And the burden at that point was upon the prosecution to demonstrate that his fear had become unreasonable, and we submit that procedurally the fact that the car was moving away did not meet that burden.
I'm having trouble understanding how that's a procedural error.
First of all, the record is clear that the defense established the elements of of self-defense. So the question is, did the state negate one of the elements of self-defense? And the standard is that they have to overcome one of the elements by on a reasonable doubt standard.
Okay. Is it your view that the district court was obliged to apply to its own findings the same standards that when deciding a federal sentence that a state court would in looking at an affirmative defense to a state prosecution for criminal recklessness?
I'm not sure whether it is probably a preponderance standard rather than a reasonable doubt standard. Just given that appears to be the standard that that is usually imposed on a sentencing judge in making findings. But here, even applying that standard, the process that was engaged in by the district court was not expressly saying that the withdrawal of the vehicle it established by a preponderance of the evidence that Mr. Cornelius no longer entertained a fear of death or great bodily harm.
Do you want to save your 2 minutes for rebuttal? Do you want to save?
Yeah,
you asked for
all
2
right.
minutes.
Yes,
Okay.
all right.
Mr. Whalen. Good morning.
Good morning, Your Honors. May it please the Court, Nathaniel Whalen here on behalf of the United States of America. This Court should defer Mr. Cornelius' sentence. Starting with the, self-defense claim, the District Court didn't clearly err in finding Mr. Cornelius was no longer under a reasonable fear of death or great bodily harm at the time the other car was driving away. Judge St. Eve, as you noted, the District Court found as a factual matter based on Mr. Cornelius' trial testimony that as the car is pulling away, he keeps shooting at the car, he blasts out the back windshield. The court, who sat through this testimony, found that at that point, Mr. Cornelius was not operating under a reasonable fear of bodily injury or harm at that point. And that's consistent with Indiana case law. The Wilson case is what the court relies upon, where it finds actually a very similar scenario. Defendants has a fear initially. People get into a car, drive away, defendant shoots at them as they're driving away. And the court found even if you initially have some aspect of self-defense at that point, you no longer have when this car is fleeing away at that point. And the district court here did actually find on page 8 and 11 of its sentencing order, which is docket 159, it was willing to accept that Mr. Cornelius was initially acting under self-defense when they start this drive-by. And according to his testimony, he's standing there, he's subject to a drive-by. What the court said then, though, is once the assailants get back in the car and drive away, consistent with Indiana precedent, consistent with Indiana case law, you're no longer operating under a reasonable fear of bodily injury at that point. That is a factual finding that's subject to clear error. And so even if there are two interpretations of the record, even if there might be some evidence that Mr. Cornelius was not acting under a reasonable fear at that point, it was not clearly erroneous to find based on his testimony to the contrary. On the other point, I'm not sure there's a whole lot to say. None of the 4-level enhancement did not increase the defendant's statutory minimum or maximum. Under this court's case law, that does not need to be submitted to a jury for proof beyond a reasonable doubt. Nothing about Erlinger changes that. Unless this court has any questions on any of the issues, we would ask you to affirm Mr. Cornelius' sentence.
Thank you, Mr. Whalen.
Thank you.
Mr. Stevens.
I think that the Erlinger case opens the door to requiring a jury finding whenever a violation of a statute makes the sentence harsher,
including through guidelines.
Pardon?
You're saying that's your position, even if the adjustment comes under advisory guidelines.
Yes, under the advisory guidelines, when the findings have to, the findings are limited by a statute that outlines elements of a crime or a conviction of a crime. I am not saying that you're entitled to a jury trial on every guideline issue. No, and what I'm saying is when the guidelines bring another statute to bear on the harshness of the penalty, that you have a Sixth Amendment right that attaches to the determination of whether that incorporated statute has been violated.
Thank you.
Thank you, Mr. Stevens. And you were appointed to represent your client in this case.
Yes,
Thank
I
you
was.
on behalf of the court for taking the appointment. Thank you, Mr. Whalen. The court will take the case under advisement, and that concludes our oral arguments for this morning.